I want to thank Arlene for the invitation to speak here today. She promised me a full house. Clearly, she delivered. If you ever need a public relations consultant, talk to Arlene. She is really good at it. Just a little bit of quick background. My wife and I, my wife Sarah, and I live over in Thorndike Gardens, the other side of town, I guess. And I have taught a couple of courses for Live and Learn. I'm going to do something else in the fall, but I haven't quite figured out what that's going to be yet, but it will be in the course catalog. All right. So, we all know, just a month ago, the Supreme Court issued a decision on abortion in Dobbs versus Jackson Women's Health Organization. The caption of it, Mississippi had passed a law that said you cannot have an abortion after the 15th week of pregnancy, which was pretty much the harshest, I think, the harshest law in the country at the time. Case went up to the Supreme Court, and the justices just recently said that that's just fine, that that law is valid, and in doing so, they reversed Roe v. Wade, and they reversed another case called Planned Parenthood versus Casey, which in 1990 had basically upheld Roe, although it made some changes to it. Now, this decision doesn't outlaw abortion, right? The Supreme Court doesn't, at least yet, have that kind of power. What it does is it turns the clock back to 1972, before Roe v. Wade. And what that means is that every state is on its own. Every state can decide whether or not it wants to make abortion illegal. Now, you don't need me to talk to you about the political consequences of that decision. You don't really need me to talk to you about the impact of that decision for women who are living in the wrong state and won't be able to travel to a state where abortion is legal. And you don't need me to talk to you about whether Justice Alito got it right when he described the history of abortion regulation in the US. All you do, turn on the television, read the newspaper, check the internet, you can find more than you can handle about all of those subjects. I want to talk to you about something a little bit different. And I'm pretty sure a lot of people in the country, and probably some of you in this room, believe that, thank goodness, after 50 years, the Supreme Court has finally corrected one of the worst mistakes it ever made. There are a lot of people who believe that. There's a lot of other people, and probably some of you in this room, who think, oh, good Lord, the Supreme Court has just made one of the worst mistakes it has ever made, and maybe ever will make. So that's my topic for today is the decision a mistake as a matter of constitutional law? Okay, because that, as I said, you don't need me to debate the politics. I'm sure we could have a very lively discussion about the politics, but the chairs might start flying and who knows. So let's not do that. So my topic is the decision a mistake as a matter of constitutional law? Now, I think you should all read the Constitution. How many people here have read the Constitution? Okay, that's a respectable number. Good. It's, you can find it in the internet or in a library. It's really pretty short. And it was written a long time ago, but there aren't that many old-fashioned legal expressions in it. So if you sat down and read it today, you would find it fairly easy to read. So you've got your Constitution. You've read it. How do you figure out, hello, is that me? Okay, if somebody hasn't turned off their phone, it would be nice if they did. Anyway, how do you figure out what the Constitution means? All right, well, let's hear from a few experts. So, okay, who knows what that was? All right, we're going to go back in time to 2005. And that guy, John Roberts, had been nominated to be Chief Justice, and he is sitting at the Senate Judiciary Committee answering their questions. And to explain what judges do, Roberts turned to baseball. And here's what Roberts said. Judges are like umpires. Umpires don't make the rules, they apply them. They make sure everybody else plays by the rules. I will decide every case based on the record, according to the rule of law, and I will remember, you gotta love this, I will remember it's my job to call balls and strikes and not to pitch or bat. Okay, so, did I just turn that off? I don't think so. There he is. Okay, so that's John Roberts as an umpire, and he apparently believes that that's what judges do. He wasn't, but this is important, he wasn't just promising to be neutral. He was promising to get it right. He told the Senate, the job of a good judge is to do as good a job as possible to get the right answer. I believe that there are right answers, and judges, if they work hard enough, are likely to come up with them. Okay, so now we're going to jump ahead 5 years. It's 2010. Sonia Sotomayor is in front of the Senate Judiciary Committee. She had a wonderful resume. She'd been a federal judge for 20 years. She'd been nominated for the court and by President Obama, and but among other things, she did have a problem. And one of her problems was that back in 2002, she went to Berkeley and she gave a speech. And it was a Latina judge's voice. Okay, she's a federal judge, she's of Latina background, and she tells the audience at Berkeley, our experiences as women and people of color affect our decisions, whether born from experience or inherent physiological or cultural differences. Our gender and national origins may and will make a difference in our judging. Now, Sandra Day O'Connor, Justice O'Connor, had once said that a wise old man and a wise old woman would reach the same result in a case. Sotomayor disagreed. She said in this speech, I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a white male who hasn't lived that life. Okay? Now that was 2002. Unfortunately, now it's 2010. And she's in front of the Senate, and the Republican white men on the Senate committee are not pleased with that speech. And they pounded on her, and she retreated from that speech with breathtaking speed. You would have had trouble keeping up with her. Among other things, she told the Senate, in the past month, many senators have asked me about my judicial philosophy. Simple, fidelity to the law. The task of a judge is not to make law, it is to apply the law. She then denied that judges rely on their personal life experiences. We have to recognize those feelings and put them aside. That's what my speech was saying. That's our job. They asked her about the wise Latina remark, and she waved her hand at that as a rhetorical flourish that fell flat. Okay, seriously? A speech about the special perspective of that a Latina woman can bring to the task of judging turns out to be a speech which says everybody leaves their personal feelings at the courthouse door. Now that's a big turnaround. Come on now, there we go. So she too is claiming to be an umpire, because she even said, I prefer to describe what judges do like umpires is to be impartial and bring an open mind to every case before them. And by an open mind, I mean a judge looks at the facts of each case, listens and understands the arguments, and applies the law as the law commands. So she too, like Roberts, is saying to you, our personal feelings don't matter. The law tells us what the result should be. So, I mean, really? Are the justices just like umpires? No way in the world. Not a bit. The idea that justices do what the Constitution requires in a perfectly impartial manner is total nonsense. Roberts and Sotomayor are way too smart to have believed what they said. I guarantee you that that's true. So why did they say it? Why did they go in front of the Senate and promise that they will be perfectly objective and do whatever the law requires? And the answer is that those Senate hearings are a ritual in this country, and they're a ritual in which the nominee has to repeat. Again, if someone could turn off their phone, that'd be cool. Thank you. The Senate hearings are a ritual in which the nominee has to say certain things that are part of the American myth of what our government is all about. We like to believe that we have a government, as Abraham Lincoln put it, of the people, by the people, and for the people. Okay, but the problem is the people don't elect those people. The people don't elect the Supreme Court. So, in a democratic government like we have, how can you justify giving 9 justices who are appointed for life the power to tell Congress, the president, the state governments, and each of us what we can or cannot do? That's a tough question. It's not necessary. Remember, though, that question goes both ways. If you like the Supreme Court to be aggressive in protecting individual rights, then you want a decision like Roe v. Wade. You want the court to say, there are some things that the states can't do even if they really want to, because there's a right there. On the other hand, from the other political perspective, they sometimes too will say, there are some things the state can't do, like pass gun control, right? There is an individual right to own a handgun that the states can't interfere with. It's the same argument being made from opposite political sides. Now, from the very beginning, it's been part of our myth, our civic religion, that it's okay to give the Supreme Court all that power. The Constitution creates limits on government, on what the government can do. Somebody's got to enforce those limits. Part of the myth is also interpreting the Constitution is law. It's not politics. Okay? You can solve constitutional questions as a matter of legal analysis, not political belief. Part of the myth is that the justices are not influenced by their personal beliefs. Part of the myth is that there are right answers to questions about the Constitution, and that the justices can figure out what those answers are. So part of the myth that we've been taught in this country is it's safe to give the Supreme Court all that power because they're just following the law in an impartial fashion. When they write opinions to explain what they do, their message is basically, the Constitution made us do it. We didn't want to do it. Sometimes they'll actually write, if it was up to me, I would vote the other way. But the Constitution makes us do it. All right. Whoops, hold on a second. Okay, so how do you justify saying the Constitution made you do it if you're a judge? Well, one way to make that argument is to just look at the text of the Constitution itself. The justices sometimes claim that the meaning of a particular clause is just obvious. You don't need fancy analysis. It's just clear on it, if you read it. And there are a few parts of the Constitution that are pretty clear. The president has to be at least 35 years old. Each state gets 2 seats in the Senate. There's nothing confusing about that. There are clear answers. But most of the interesting stuff, and most of the important stuff, is complicated. It's not clear. It's not obvious. And so I want to give you an example. This is the Establishment Clause. It's part of the First Amendment. And it says that Congress shall make no law respecting an establishment of religion. Okay, now the Constitution doesn't define establishment, and it doesn't define religion. But if you have to interpret that clause, what do you think it means? Now, reading it, it sounds like it probably means that Congress can't make the Presbyterians or the Methodists or the Catholics the official religion of the United States. Okay, remember, the colonists had just broken away from Great Britain, which had an official religion of the country. They didn't want one of those for the nation here. So it probably means that, but establishment of religion might mean a whole lot more. Okay, so what about in public schools? What about requiring a public school to start every day with a prayer? Okay, that was common back in the 50s. Some places started with the Lord's Prayer, some with a prayer, non-denominational prayer that some bureaucrat had written. How about reimbursing Catholic parents for what it costs for the bus so they can send their kids to parochial school? How about providing science and history textbooks to religious schools? How about having, we all love these, a holiday display for Christmas that includes a manger scene, along with Santa Claus and Rudolph and all that stuff, plunking in a manger scene, like Pawtucket did in a famous case some decades ago. Every one of those things I just mentioned to you, the court has ruled that some of those are okay and some of them are not. And in every single case, the justices were bitterly divided about what was the right answer. My point is, on a lot of the best stuff, the most interesting stuff, the language of the Constitution doesn't answer the question for you. You got to bring some other meaning into it. All right, so let's go back to John Roberts for a second. Here's another argument that the justices sometimes use to tell you the Constitution made us do it. He told the Senate that he was going to find correct answers. And where was he going to find them? He said, the framers' intent is the guiding principle that should apply. Okay, so the framers is one of those civics words for the folks at the Constitutional Convention. And the idea that you decide a case based on the framers' intent is often known as an original intent approach. And original intent has been the rallying cry of conservatives in this country since the 1960s. Back then, they said, the liberal justices on the Warren Court are just making it up to suit their liberal politics. What we should do is find correct answers in the original intent of the framers. Justice Scalia, there he is. Justice Scalia was the most famous advocate of an original intent approach. Today, all 6 of the conservative justices will say that when they are faced with a difficult question about what the Constitution means, they rely on the original intent of the framers. And that's an appealing argument, right? I mean, if you're trying to interpret a somewhat confusing document, and you probably get confusing documents from time to time, don't you sometimes ask yourself, I wonder what the person who wrote this had in mind? Right? I mean, that's a natural thing to want to know. It might help you understand what a document means. And conservatives claim not only is it the right thing to do, but it will produce correct answers. Because when you study the framers' intent, there's only one intent that you locate, and that's what you rely on. Taking a step back for a second, for the last 50 years, people have been arguing about whether judges are just making it up or whether they apply strict rules. And the recurring theme for the conservatives is you gotta have strict rules, and the recurring theme for liberal justices is you have to be more flexible based on what the needs of contemporary life. All right, so but the conservatives rely on original intent, is it possible to actually do that, to actually find the framers' original intent? So there's a nice painting of the guys at the Constitutional Convention. You got George Washington standing up tall on the top there, Ben Franklin sitting in the lower center. Alexander Hamilton is whispering in Franklin's ear, and somewhere to the right of Franklin as we look at it is James Madison sort of squirreled down taking notes. He took pretty good, he tried really hard to take good notes. Okay, so here's what the original intent is telling you. 55 men went to the convention. 39 of them stuck around for the end and signed the final Constitution. So that argument is telling you that all 39 of those people who signed it were basically thinking the same thing. Now, we're the Constitutional Convention. Okay, we're a bit bigger. We wouldn't all fit in that room in Philadelphia, but suppose we're the convention. People stand up and make suggestions about what would be a good thing to put in the Constitution. People then debate whether it would be a good thing or not. After a while, we vote on the suggestions, some up, some down. Somebody puts together the things that were approved and writes out a final version, and then we all vote on whether or not we're going to sign that final version. Can anybody believe that all of us were thinking the same thing? Right? I mean, decisions, why people make decisions is pretty complicated. I mean, just ask two people who are getting a divorce. Why are they getting divorced? You know, they know, they have firsthand knowledge, but they're not going to give you the same story, most likely. This is a decision on a much bigger level. Each one of us who votes for the Constitution is going to have a different idea about what the words mean, about how it would work in practice, and whether it was a good, whether certain parts of it were a good idea. Okay, but even if you make a leap of faith and you, wonder how that happened. Even if you make a leap of faith and you say, all right, everybody who voted for the Constitution was thinking the same thing, how do you know what it was? They've been dead for 225 years. I can't read minds, you can't read minds, and those minds are dead. So some of the delegates took notes, and James Madison did take very careful notes, but the estimate is he was barely able to write down 20% of what people said. There's no transcript. So the fact is, we don't know what they all said during that summer in Philadelphia. We have some idea on some points, but we certainly don't know everything. And even if we did, we wouldn't be able to read the minds of the people who said those things to be sure we knew why they said them. The idea that you can use original intent to interpret the Constitution is pure fantasy. And by a very strange coincidence, the people who rely on original intent to answer questions about the Constitution almost always settle on the politically conservative result. I'm not saying that that's sinister, necessarily, but I am certainly saying that it's no accident that original intent and the politics of the conservative justices seem to go hand in hand. One of the best examples is that gun control case, Heller versus District of Columbia from about 15 years ago. The question was whether the District of Columbia could prohibit handguns. So Justice Scalia, it's one of his most famous opinions. He spends 60, 70 pages going through the history of how people use the words in the 18th century to conclude that what the Second Amendment says creates an individual right for each of us to own a handgun. Justice John Paul Stevens spends 50 pages of his own going through the historical record of how people used words like militia or keep and bear arms, figure out how people use those phrases in the 18th century, and John Paul Stevens came up with exactly the opposite answer, that it only protects having a gun if you're in a militia. Now, since then, most scholars would have said that Stevens had the better argument. he was closer to the, more true to the historical record than Scalia was. But Scalia had 5 votes. Stevens only had 4 votes. So Scalia's view prevailed. All right. Now, there's an even bigger problem with original intent as a theory. Those guys truly believed in liberty and inalienable rights. Yes, they certainly did. But they also believed that married women had no rights and had no legal existence. Once a woman married a man, she disappeared in the law. The husband made all the decisions. Now, those people, almost all of them, believed it was perfectly fine to buy and sell black people as property. Right? Those people, and particularly if you think about those of them from a Puritan place like New England, I mean, they believed that it was perfectly okay to put gay and lesbian people in jail simply because of who they are and what they do. Those men believed that the only people who should vote are white men who have a certain amount of property. And those folks also believed that the white settlers in North America had a God-given right to drive the American Indians off of their land. Now, some of what those folks believed in, we still like to believe in. Many of those things we don't. And let's face it, I don't think too many of us would really want to volunteer to go back to the world of 1787. Certainly not any of the women in here, I'm pretty sure. But, you know, perhaps not most of the men. I mean, if you don't have enough property, you don't vote, and who knows where you're going to end up. So you don't, I mean, it's not just that the world of 1787 did not have indoor plumbing and did not have antibiotics. It's also that it's a world in which many of the values that they took for granted, we don't feel comfortable about at all today. So, do you really want to be governed by what people who believed all of that package thought was the right way to live? You can. All right, so I've shot down the text as a theory of getting correct answers. I've taken some swipes at original intent as a theory. So how do you interpret the Constitution? Well, William Brennan, one of the most famous liberal justices of all time, in an article attacking the original intent idea, he said, the ultimate question must be, what do the words of the text mean in our time? For the genius of the Constitution rests not in any static meaning it may have had in a world that is dead and gone, but in the adaptability of its great principles to cope with current problems and current needs. Some commentators call that a living Constitution approach. And I mean, on one level, that sounds pretty sensible too. I mean, who wants a dead Constitution? You know, you want a Constitution that kind of keeps up with the times. But there are some problems with that approach too. How do you know what those great principles are? The Constitution doesn't tell you. The best you get in the Constitution is the preamble. So there it is. It's kind of a mission statement that they put at the top before they got to the details. And you know, you've all heard those phrases from time to time. There's nothing too specific in there, right? I mean, to establish justice, all right? We're all in favor of that, but what does that mean in practice? General welfare, blessings of liberty, those are nice words, but you can't use that as a set of principles you can really apply to in the here and now. The real problem with the living Constitution approach is that it's really obvious there are no correct answers. Because if you want to ask yourself what's an unreasonable search and seizure today, or what are the rules for when the police want to question a criminal suspect? You know, think of the Miranda warnings. That was an invention by the Supreme Court in the 60s. So if you start trying to answer questions about how you want the Constitution to apply today, we all have kind of an equal vote. I mean, the justices have know more about the history of the Constitution, but their view about what justice should mean isn't any more important than any of yours. So the trouble with the living Constitution approach is it cannot give you correct answers. Everything is up for grabs. What do the principles mean today? And that is always going to be a judgment call. Okay, so at long last, let's get to the topic of abortion. How does the Supreme Court explain its answers in cases involving abortion? And actually, we have to take a step back to birth control. So to get to the subject of abortion, we have to go through the Griswold versus Connecticut case. It appears a lot in the opinions in the Dobbs case. And in 1960, the FDA approved the birth control pill. Okay, huge breakthrough in the ability of women to prevent pregnancy. At that time, in 1960, it was a crime in the state of Connecticut to use or help somebody else use birth control. It wasn't the only state that had a rule like that. As soon as the Planned Parenthood Center in New Haven started helping women get the birth control pill, a Catholic neighbor complained to the police, and Estelle Griswold there, she was the head of that local Planned Parenthood office, she got convicted and fined $100. Now, $100 is not a lot of money, but she insisted on, of course, on taking her conviction to the Supreme Court. And the Supreme Court in 1965 reversed her conviction. Okay, and William O. Douglas, Justice William O. Douglas wrote the opinion. So you got to ask yourselves, I presume that nobody much in here would really like the police to be conducting searches of people's bedrooms looking for contraceptives, right? Condoms, birth control pills, whatever it might be. We really don't want the police doing that. But that doesn't mean it's unconstitutional, right? You got to ask yourself, is there something in the Constitution that says the police can't rummage around in people's houses, in their bedrooms, looking for birth control devices? The Constitution doesn't say anything about birth control. Douglas wanted to develop the concept of a right to privacy that was big enough to cover using birth control. The Constitution doesn't say anything about a right to privacy either. So Douglas had to get creative. And I'll just give you a little bit of an idea. So the specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that give them life and substance. And then he starts rattling off amendments. You got the First Amendment that protects your freedom of speech, freedom of thought, freedom of religion. You got the Third Amendment, which people forget, but it says the government can't force you to, quarter soldiers in your own home, which was a big deal in the colonies. So your home is safe from the U.S. Army in that sense. The Fourth Amendment protects you from unreasonable searches and seizures. The Fifth Amendment creates a privilege against self-incrimination. Both the Fourth and the 15th Amendments say that the government can't take away your life, your liberty, or your property without due process. And then there's a Ninth Amendment, which actually says people have other rights that we just haven't mentioned. Okay? Nothing in the fact that we've listed some rights means there aren't more. All right, so throwing all those amendments together, Douglas says this case concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. What relationship is he talking about? In this case, he's talking about marriage. because the law was being applied to prevent a doctor from prescribing birth control for a married couple. So, now, Douglas's devotion to the institution of marriage was somewhat ironic since he had already been married 3 times. And there was a 4th one coming down the pike. Nevertheless, okay, so he basically throws a lot of amendments into the pot, stirs it for a little bit, adds some emanations and some penumbras, and says there's a right to privacy that includes the right to use birth control. Now, most people in 1965 agreed with the result, the concept that Connecticut shouldn't be able to prohibit birth control, but an awful lot of people sort of got the sense that Douglas was making it up, that it was a pretty intellectually sloppy justification for the result. All right, so 8 years later, we get Roe v. Wade. Norma McCorvey sues the state of Texas, where abortion was a crime. She finds Sarah Weddington, a lawyer who will help take her case to the Supreme Court. McCorvey and Weddington win. The vote was 7-2, and there were only 3 liberal Democrats on the court. They were left over from the Warren Court. So that 4 Republican justices voted in favor of Roe v. Wade. 3 of them had just been appointed by Richard Nixon. Okay, so this is not like a wild, crazy liberal court inventing a right to get an abortion. This is a court that's moving more and more conservative, run by Warren Burger at this point. The opinion was written by Harry Blackmun, one of the Republicans that Nixon had just appointed. Blackmun had only been on the court 2 years at this point, and he was not yet a liberal in the way that we think of him later on. So what does he do? He doesn't do what Douglas does. He asserts there is a right to personal privacy. It exists. It's protected by due process, and it's broad enough to cover the right to an abortion. So he has a specific basis. Liberty protected by the due process clause. Okay, so, whoops, go back there. The Constitution doesn't define liberty, and it doesn't define due process. For more than 100 years, the justices have been saying that liberty means more than just they can't put you in jail without giving you a trial. That there are other things that we do that are protected as liberty. And no matter what kind of majority votes for them, the government can't do it if it interferes with your liberty. Okay, but so what's liberty? Everything we do protected liberty? If not, like everything we do, is any law that interferes with your freedom of choice unconstitutional? Stop signs? Speed limits? You think about it, every day we do all sorts of things. Somewhere out there, some of those things are protected by the Constitution, and others are not, because some of them fall into the category of liberty and others do not. Now, the Constitution does not tell you how to define liberty. And Harry Blackmun did not claim that the people in 1787 believed that liberty included the right to get an abortion. Blackmun was making a living Constitution argument. He was saying to you, this is what liberty means to us in America today. It's a broad enough concept that it includes many things, among them being a woman's choice to get an abortion. Okay, so then we get to the Dobbs decision, and Justice Samuel Alito says Roe v. Wade was wrong, and women don't have a constitutional right to get an abortion. And that kind of raises the question, all right, so not just what is liberty, but like what are rights? We use that sentence all the time. I have a right to this. I have a right to that. Okay? Sometimes you hear it in phrases like every human being has a right to be treated with dignity and respect. Everyone has a right to a good education. You're probably... Back in the 1930s, and I'm not sure we've played this yet, but back in the 1930s, there was a song called "I Got a Right to Sing the Blues." Louis Armstrong, Billie Holiday sang that song. Okay, so what does it mean to have a right? Okay, I mean, think about it. When we say we have something, a lot of the time we're talking about objects, right? I have a dog. I have a Toyota. Sometimes we're talking about personal qualities. I have red hair. I don't. I have a bald spot. I have a headache, things like that. So if you want to say that a woman has a right to get an abortion, you're not just saying, I really, really, really think it's important that women should have that choice. You're saying something in the Constitution says women get to make that choice. Now, for the Supreme Court, the Bill of Rights obviously doesn't say anything about a right to an abortion. And for Justice Clarence Thomas, on the left there, for Thomas, that's all you need to know. The only rights you have are the ones spelled out in the Bill of Rights. That's it. Anything else is an invention by liberal judges. That's basically his view. Justice Alito wasn't prepared to go that far. He agreed that for 100 years, the court has defended some things as protected liberty, even though they're not written out into the text of the Constitution. Okay, so how do you know what liberty is protected? Alito's answer is, I should think if only I could do Zero Mostel. Tradition, right? History and tradition is how you know what the rights are that are not spelled out. And these are the key, what I thought might be the key sentences in his opinion. A right to privacy is not implicit in the liberty protected by due process. The only thing you get are rights that have been protected by history and tradition for a long time. Thank you. Now, Alito and conservatives like Alito are very afraid that if you don't have some fixed way of drawing a line, this is liberty, this isn't, all bets are off. It's anything anybody wants. And so it's not a crazy idea to try to say there's got to be some objective way of figuring out what's protected and what isn't. The trouble is, if you only do the history and traditions approach, you've got the Bill of Rights and you've got what the history of this country has protected, what you basically get are rights that the prosperous white men who have run this country since 1787 think are important, right? Because if it's been protected by history and tradition, that means Congress or state legislatures or courts have recognized it for quite a long time. And up until pretty recently, that was only pretty well-to-do white men. Now, I'm a well-to-do white man, so there's nothing inherently wrong with us. But it is a partial view of the world. Now, Alito said, you don't have to worry about the consequences because the abortion issue is unique. Because it involves the taking of a human life, it's unlike any of the other cases that come to us that involve liberty. Maybe, but I don't know that I'd believe him. So here's the thing. Once you adopt the history and traditions approach, you might have to revisit a whole lot of other stuff, right? And the dissenting opinion in Dobbs does a pretty good job of flagging what some of those things are. I mean, remember, in 1984, there was a long history and tradition of segregated schools in this country, especially in the South. And there had been segregation here in the North through the 19th century. If you always use the history and traditions approach, you'd go back to having official prayers to start the public school day. The government could pretty much discriminate against women any way it wanted, right? Because there's nothing in the Constitution that prevents gender discrimination. Back to history and tradition, the states can go back to prohibiting birth control. There's a pretty good argument that that would be true. It's certainly the case, and you can tell that Justice Thomas is just drooling at this prospect, that the states could prevent gays and lesbians from getting married. Let's reverse that case too. But the argument is pretty subversive because there was a pretty long history and tradition of not letting black people and white people get married. Even into the 1960s, there were a number of states that it was still illegal until the Supreme Court ruled in 1967 that a state can't prevent that. But if you use the history and tradition approach, that interracial marriage was illegal everywhere in the 19th century and most of the states through the first half of the 20th century. So, who knows what will happen next? I don't know any more than you do. All right, so where have I gotten us? Besides probably exhausted. I apologize for talking too fast. So I started by posing the question, is the Dobbs decision correct as a matter of constitutional law? And it was a trick question. Because as far as I can tell, I hate to break it to you, there are no correct and incorrect answers to questions about the Constitution. Remember, the words on the page don't define themselves. That establishment clause that we looked at, that's pretty ambiguous. There's all sorts of real-world situations where it's pretty hard to know what it might mean. You can't use the intent of the people who wrote the Constitution because you don't know what it was. You cannot figure out what it was. It is pretty clear that all bets are off and that when the justices deal with these complicated questions, they're talking constitutional law, but at the same time, they're folding in their political and social beliefs. And on both sides, clearly. It's pretty obvious that the 6 justices in the majority in Dobbs, if you look at their record, they are deeply conservative on every single social and political issue you can think of. Some of the conservative justices in recent memory, like Sandra Day O'Connor or Anthony Kennedy, they had liberal dimensions. These folks don't seem to. All 6 of them are also Catholics who believe that abortion is morally wrong. And that's a perfectly legitimate belief, but you can't help but wonder how much they were influenced by that. That not only is the result in Dobbs consistent with their judicial philosophy, it happens by coincidence to be consistent with their religious philosophy. So, we've had decisions in the past where the court was pretty obviously political. You all remember Bush v. Gore, right? In 2000, the Supreme Court, the 5 conservatives, handed the election to George W. Bush. Now, somehow, the court's reputation survived that one. I don't know that that's going to happen this time, because it is obviously getting harder and harder to believe the myth that that the Supreme Court is not playing politics. And people seem to have already changed their views a bit. I went online yesterday to find some polling. In March of this year, 54% of the people polled approved of the job the Supreme Court was doing. 2 months later, after Alito's draft opinion came out, it dropped to 44%. 2 months later, when the official opinion came out, it dropped to 38%. So barely a third of the people polled think this Supreme Court is doing a good job. You know what? Those 6 conservative justices don't care, because they're not voting based on what you and I or anybody else might believe. William Brennan used to say, when he was at the Supreme Court, with 5 votes, you can do anything here. And the conservatives have 6 votes, and they can do anything they want. This is the most conservative court in 100 years, perhaps the most conservative court ever. If you like what the court is doing, and plenty of people do, and I'm sure some of you in this room do, you can just sit back and enjoy the show, because they're going to keep doing it for the foreseeable future. If you don't like what the current court is doing, The only solution, right, is to win presidential elections and pack the court in the opposite direction, right? I mean, Republican presidents tried to pack the court to get to Dobbs. It took them 40 years to get there. Donald Trump finally succeeded. All right, I'm sad to say, I think it is all politics. I'm really sorry. I wish that wasn't true. I wish the myth was true. But as far as I can tell, it isn't. Anyway, I appreciate your patience. Thank you all.